Welcome to Property Deconstructed. I'm Pat Panetta from Tell Your Story Media. Mark Ericello's here from Master Builders Real Estate Services. And we're talking the law, Mark, and we've had a good chat with John Melia, but now this is sort of part two in a way, where we're moving to the next stage of what you need to know when purchasing a property and the law.
Yes, yeah. Thanks, Pat. Thanks again for having us here. So, yes, we're in episode 5. We discussed with John from Melia Lawyers, what to do with pre-purchase reviews. And now in this episode, we're discussing the other end of the transaction when you actually settle, your settlement comes up, final inspections and acquiring the asset.
Yeah, love it.
Yeah,
because that's still an opportunity. You're not, not the end of the race yet. So you're getting closer to getting there, but at this stage, you still need to have your radar on.
Things get hairy sometimes where the other, vendors may not be abiding by their obligations at the end of handover. And especially with final inspections or what was, the conditions and terms of the contract. So,
yes.
John, thanks again for joining us, John. And, if there's any particular risk or part that, or discussing what you do at Melia Lawyers with the settlement process and advice for the clients.
Yeah, before we go into that, Pat and Mark, in relation to, signing the contract, just to let the listeners and viewers know that you've got 3 clear business days to cool off when you sign a contract at a private sale. So if you sign the contract and pay the deposit and change your mind, you've got 3 clear business days to pull out. After the 3 clear business days, that's it. You're stuck.
Right.
And if you purchase at an auction, there's no cooling off period allowed.
Oh, okay.
It's a very important
So that's
point.
important,
Yeah. So it's so important. You've got the cooling off period, but if you purchase from an auction, you don't.
You don't, no. And John, the cooling off in private sale, that's 3 business days, clear days from the day that you sign the offer,
Correct.
not the day that the vendor.
From the day you sign it, yeah.
That's something that usually confuses people. They think it's 3 days from the date of acceptance or day of sale when the vendor accepts.
The day you sign it.
It's the day you sign. So the owner may, or the agent sometimes may wait your 3 business days before they give you an answer. So that's where, there's a clear date which states the date your offer will expire outside of, there's a section of the contract, the field in the contract where you can specify how many days you'll leave your offer open.
Yes.
Generally, I wouldn't leave it to the end of the 3 business days for the cooling off period. You don't want an answer in the final hour. So that's a really good point to raise, John.
And sorry to interrupt. The other thing is too, if you're getting finance for your purchase,
yes,
right, you can make the contract subject to finance.
Yes.
So if you don't get your finance approved within the time limit, you can pull out of the contract and get your deposit refunded.
Right. So I've done that in recent times. So you're subject to finance. Is there any sort of curly things you need to know with that? If I pulled out, if I didn't get the finance,
you've got to make sure you actually have applied for the finance and have some proof from the lender or the mortgagee to say, you're not getting approved.
Yeah. So you didn't sort of waste everybody's time, basically.
Correct.
It's
correct.
Great,
And also you can make it subject to building and pest inspection.
Oh, yes.
So you can get someone to come in and do a building inspection report and a pest inspection report.
Yeah.
And if the property's not up to scratch, and there's a lot of work to be done, you can pull out.
Yeah. I had a property inspection and a pest inspection, and he did a good job. I found somebody just through Google, but
we've had Mohammed Jabib
Mohammed,
from
that's right.
Victorian Building Inspections on
Mohammed
as well.
to do it. He would be great because this guy was a bit sort of. I sent me a whole bunch of stuff, and I read it all, but I then rang him and said, "Is there anything wrong with the property?" So I wanted to talk to a real person.
Yes. But same with that, all these great special conditions to be aware of that, yes, depending on, we go back to that word leverage, who else is competing at the time, the motivation of the vendor and the agent, put in and load up as many special conditions as you can to protect yourself. And like John mentioned, if the lender says you've been declined and you've had that special condition there for the finance, special condition of finance pre-approval, there's evidence that you've been declined. Same with the building and pest inspections. They'd have to note there's a major defect. You can walk away without penalty, have all money refunded.
Okay.
And now important, the residential tenancy minimum standards in Victoria, if you're buying as an investment, you've got to make sure that your property you're buying meets the standard building codes, the safety checks for electrical, plumbing, where possible.
So subject to all that as well.
Where possible, I've had that success in adding it as a special condition, similar to the building clause, but it is hard. You know, it gets there's compromise in negotiation. How heavy can you load it up?
Yeah. Well, that's true. I mean, there's a bit of gut instinct when you make purchases like this as well, but you don't want to be naive.
Yes.
Yeah, I mean, you can't spend, 6 months inspecting it all and whatever. You think, okay, it seems to be okay, let's move forward type thing.
You can still invest without having it as a special condition. You can still invest in the checks and get it done at your risk that you're putting the money forward and you may not be successful with the purchase, but you can still do your due diligence even if you can't get the special condition afforded on the contract.
Okay, yeah, of course. John, do sometimes people just, it's such an emotional decision and purchase. He's got a guest in there. He's very popular, John. He's coming to us live from his new premises too, which we'll ask him about later. But do you often get people who just sort of, they're emotional and they don't sort of take your advice and go, oh, John, I just want to move forward and do it anyway?
Correct. We do. We get a lot of people who do that. And unfortunately, we explain to them what can happen and what can go wrong, and they take it at their own risk. So we can't do much once it's been done.
Yeah.
All we can do is help move transition to settlement. But there's not a lot we can do unless there's special conditions put in their favour that you've discussed.
Yes.
And unfortunately, settlement should be an easy and smooth process. You would think. Think again. So one of the biggest issues is delays on the part of the bank. So a lot of times the banks will have an issue with the mortgage documents or something with the loan. So they may not make settlement on the day that it's due to happen.
Yes.
And it's frustrating for us because we can't control that. And all we can do is ask the vendor if we can extend the settlement date without the granting of penalty interest. But what will happen is penalty interest will be applied normally by vendors. Right. So that's something we can't control, what happens with the banks during settlement. Issues that arise during settlement will be when Mark goes and does a final inspection with the client. The contract and the law says basically buyer beware. So, and there's a term called caveat emptor, right? Buyer beware. You take the premises as you find it. So basically, when you go and buy the property on that day, check everything out. Check the switches, the fans, the lights, the gas, the air conditioning, the heating, the walls. If you find that...
Should you have a shower in there?
If you could, you should.
Yes,
test the water pressure.
Test the water pressure. But what you need to do is basically how you see the property when you buy it. If it's not the same when you go on your final inspection, that is...
Right.
Things have been damaged or altered or items have been removed that are specifically being sold with the property, then you have an issue. And we see a lot of disputes over that.
And Mohammed, will he test all that stuff for you?
I was what John was resonating with me then. What John was saying is that yes, you need to highlight any issues or discrepancies at the final inspection, but at least the building inspectors, plumbers, electricians, that's a document of evidence. Otherwise, really, John, it would be my word against theirs. Is that right? If I say
correct, that's right. But what happens is normally, as we get close to settlement, and again we get back to Pat's word, leverage, we have issues where something, for example, the oven might not work, or someone's left rubbish in the property, like heaps of rubbish when they're vacated.
It's common.
Rubbish that will require a couple $1,000s worth of removal. So what we can do then is under the contract, we can either negotiate that comes off the price at the end, or there's a general condition in the contract that allows if there's any damage or issues, one of the solicitors or conveyancers on each side holds the sum of $5,000 in trust, so that once settlement happens, it can be resolved as to how much and what's got to be spent, and then that's adjusted between the parties. So until that happens, that's one of the options under the contract. And then if there's really major damage or issues, then that weren't identified, then the issue will then be that the contract You can't pull out. The settlement will still happen. Settlement still has to go through under the contract. The only way you can stop settlement if there's a defect in the title. If there's no defect in the title, which normally there isn't, you can't stop settlement. All you can do is after settlement, make a claim for damages against the vendor. And then you'd have to issue legal proceedings in the appropriate court and sue the vendor for any damages and claim them under the contract.
The leverage would be that 5,000 in trust,
correct,
essentially, to come to the party rather than going through litigation.
Right.
But if it's greater than that amount, then you'll be in litigation after settlement.
And going back to the pre-purchase review, I've noticed that $5,000 condition removed sometimes where they don't agree to have that special condition afforded to the purchaser. Is that something that's...
It's actually a general condition and they shouldn't be removing it. And I would say that it's illegal to do that.
Yeah. Right. So then that's where you can, in the pre-purchase review, your solicitor would highlight that and, correct the other side's legal representative.
Correct.
Yep.
So that's some of the things we see with getting towards settlement, or it might be an issue where some of the other issues we see with settlement are that the other person sold their house a bit too early. They got nowhere to live and they need to come in early to move in before settlement. So we can do that through what's called a license agreement. So we can do a license agreement between the vendor and the purchaser and for example, the vendor might charge them $1 a day rent or whatever they want, and the person can move in. And the issue with that is for the for the vendor is they carry the risk still of the new owner moving in until settlement. They technically own the property still. So if they damage the property, the new purchaser, the vendor might be at risk.
And so it gets a bit, the waters
gets a bit messy.
Muddy. Yeah.
So you got to go stay at Mark's house and get in the spare room.
Or short stay if they're available. Now that events are back on in Melbourne, it's a bit hard. But before you could go to a short stay and get someone to take care of you.
Yeah. So there's a bit of trust to let them into the house early because, as you say, the vendor still owns the property.
Yep, but still carries the risk. But it does happen. It can be done and it works out all the time. There's never, in 20 years, I've not seen an issue with that.
Yes.
Okay.
Because it'd be unusual to get into a house and damage it,
Oh, look, it happens. And I think sometimes buyers assume that the vendors are going to clean or garden. They don't need to do that. When John's talking about rubbish, it's like usually debris or cans and pots and paint and, other materials left behind or just general rubbish. But people do it out of the kindness of their mutual respect.
Most people
hand over that little bit of cleaning and gardening, but I've seen jungles sometimes, and there's nothing you can do about that, is there, John?
No, nothing. You can't really do anything except, force some leverage and say, look, deduct X, Y out of the settlement at the end or the statement of adjustments, so that we cover the costs of getting that done.
Back to that leverage thing, you remind me there was a place near me, there were some plumbers there on the weekend doing some work, and I think I'm not going to name any names, but there was the person purchasing the property said, well, I'm not going to do the deal unless you put a tap in, unless you do something. So that's the other leverage. So the person selling the property had to employ the plumber to fix all this up before
part of the
he or she signed.
Pre-signing, so before negotiations finalised.
Yeah, so you can be a bit hardcore that way. And
you can be, but then the ball's in the vendor's court whether they want the sale or not.
Yeah.
That's right. Well, he did it.
And is it worth missing out on the property over, a tap, I guess? It depends.
Yes.
Depends on the competition.
That's right. And I think he was paying the price that was that they want on the market. Yeah. All right, I'll get a tap in there and off we go type thing. So, that's why you need a lawyer, John, because there is a lot of back and forth.
There's a lot of back and forth, toing and froing, and issues always arise. There's always something, whether it's an issue with the bank, whether it's an issue with the third party. There's always an issue. So you would think settlement would be smooth and simple. Most times it is, but unfortunately there are issues that do arise.
Mark, with all this stress that John has to deal with every day, he still looks young and handsome and fine and relaxed.
You're too kind.
Good lighting.
Too kind.
Good lighting, must be. We've airbrushed it.
And that's that's really helpful, John. And thanks for sharing that as well for the settlement process. And then I guess you handle as solicitors other areas post settlement, like the discussions of wills and estates and asset protection. That's something that
we do all that, and we can come back and talk about that another time. It
That'll be
all
good.
falls within what you do.
Future episode.
Talk about that, and leasing and leases. We can talk about that.
Very interesting stuff. Yeah, we'll cover all that. Now, I mentioned earlier that you are at new premises. You're based in Melbourne, John. So how's the new offices going?
Very good. We've moved to 107 Gaffney Street in Coburg, and we just ran out of room where we were, and we've got plenty of room now, so we're very happy.
Yeah,
good part of town there.
Yeah, right opposite Bunnings and the Lincoln Mills Homemaker Centre, so easy to find. Yeah, the Batman Post Office.
That's right. Northland's not too far from there.
No, it's probably 20 minutes
20
away.
minutes, okay.
Closer to Preston, Northland.
Oh, there we are. Okay. Well, Mark's given the location
geographical
better than me.
pin.
Yeah. 107 Gaffney Street, Coburg is where you'll find John. And we appreciate your time. It's been a great little chat, Mark.
It has been. It's been great.
That's
Thanks, Mark, and
thanks, John.
That's episode 6, The Law for the Purchaser, with the final inspection, consultation and settlement process with our special guest, John Melia from Melia Lawyers, Barristers and Solicitors. Thanks for your time, mate. Well done. Thank you.
Thanks, Pat. Thanks, Mark.